All right, Mr. Chair, we're live on YouTube, so whenever you'd like to start, please go ahead. Mr. Chair, your microphone. Thank you.
Oh, that one too. Okay. Good afternoon and welcome back to the members of the public, some of which who are now appearing in person. In accordance with Section 45 and 53 of the Planning Act 1990 as amended, this meeting of the Committee of Adjustment of the City of Toronto is called to order. Committee of Adjustment considers applications for variances from the provisions of the zoning that apply to the property, permissions to extend or alter lawful non-conforming uses, and consents to sever properties to create new lots. That's what we're going to mainly be dealing with that last point this afternoon in the 4 out of the 5 hearings item matters. Land acknowledgement. We acknowledge that the land we are meeting on is the traditional territory of many nations, including the Mississaugas of the Credit, the Anishinaabe, the Chippewa, the Haudenosaunee, and the Wendat peoples, and is now home to many diverse First Nation, Inuit, and Métis peoples. We also acknowledge that Toronto is covered by Treaty 13 with the Mississaugas of the Credit. Just hang on, I'm just checking to see if I'm reading from the right speech. Madam Secretary Treasurer, I don't seem to have the revised opening remarks. Perhaps if I could get another copy.
Adam.
Because I think they, oh, here, okay, I do have it. Okay, I saw the extra line in the land acknowledgement, so I'll start that over. We acknowledge that the land we're meeting on is traditional territory of many nations, including the Mississaugas of the Credit, the Anishinaabe, the Chippewa, the Haudenosaunee, and the Wendat peoples, and is now home to many diverse First Nation, Inuit, and Métis peoples. We also acknowledge that Toronto is covered by Treaty 13 with the Mississaugas of the Credit and the Williams Treaty signed with the multiple Mississaugas of the Credit bands. Committee of Adjustment hearings, public hearings, are now conducted in a hybrid, in-person, and virtual format. Some applicants and participants will make their submissions in person, and others will participate virtually by electronic means through WebEx, an online digital platform. The meetings are also streamed on the Toronto City Planning YouTube channel, and anyone wishing to view the hearing may watch on YouTube. Those who want to participate virtually and have registered in advance will be connecting with their computer, tablet, smartphone, or telephone and have the option of participating via video or audio only. All participants will automatically be muted on entry, and when your item is called, you will be unmuted by the moderator, one person at a time. We also ask that you mute your devices until you are called on to speak. Those participating by video appearance will be temporarily upgraded to panelist when your item is being held. During this time, your camera will be enabled. You will only be visible during your 5-minute allotted speaking time, and at all other times, your video will be disabled and you will be reinstated as an attendee. For both in-person and virtual participants, Committee of Adjustment staff will share presentations submitted in accordance with the written submission deadline. Those participating through WebEx are not allowed to use share screen or any other panelist controls during a video appearance. The host will remove you from the panelist role if you fail to respect this instruction. People attending in person today who want to receive a copy of the decision of the committee on an application must fill out a decision request card, and those participating virtually need to submit a written request for a decision by email. Please ensure that you include your name, address, and email address, because the Committee of Adjustment and in the event of an appeal, the Toronto Local Appeal Body will be sending notifications and appeal updates by email. If you do not agree with the decision of a committee, you may be able to appeal the decision to the Toronto Local Appeal Body, or in some limited circumstances to the Ontario Land Tribunal. However, the provincial government has amended the Planning Act and generally removed rights of third parties to appeal Committee of Adjustment decisions. Only the applicant, the Minister of Municipal Affairs and Housing, specified persons and public bodies, as those terms are defined in the Planning Act, are permitted to appeal decisions of the Committee of Adjustment. Appeal instructions are set out at the bottom of the decision of the committee. The hearing procedure. We'll go in order. We start, I guess, at item number 20, and we go in order. Where an application is uncontested, the agent or applicant may proceed with a presentation if desired. Where the committee does not require a presentation, applicants are to advise the chair should they wish to address the committee. The committee may ask questions and then take the matter into committee for a decision. Each speaker, including the applicant or agent, will be given a maximum of 5 minutes to address the committee, and the clock is shown on the board, and we'll comment when you're reaching a 5-minute mark, count down to 0, and ask you to wrap up. Any presentation or other materials you wish to submit to the committee must have been emailed in advance of the hearing. Staff and committee members cannot accept materials at the hearing. When addressing the committee, please start off by clearly stating your name and address for the record, and please remember to confine your remarks to the matters outlined in the application. The applicant or agent goes first and makes their presentation to the committee on the application. Please note that the committee may not entertain revisions made to proposals at the hearing today. The committee may decide to defer the application if substantially revised in order to ensure that the revised application is accurate and that all those who are entitled to notice of the application have been informed of the changes. Then individuals either in support or opposed to the application will be invited to speak. I lost my spot. Either other people are invited to speak, and generally we first call on speakers in the hearing room and then those participating through WebEx in the event that there are both parties on person and on WebEx who wish to speak. Committee members may ask questions of each speaker after they finish their presentations, and when all speakers are finished, the applicant or agent has another opportunity to rebut only those issues and answer those questions that were raised by the speaker, not to introduce new information. And that will then mark the end of the discussion, and the matter is taken into the committee. You'll hear a discussion and a decision. Are there any declarations of interest of the panel or staff of the items before us this afternoon to declare? Okay, and lastly, now that we're back in person, we'll do some introductions, starting at the end. The Secretary-Treasurer, Barbara Botowczyk, Member Neil Palmer, Member Laura Alderson, I am Michael Clark, the panel chair, Member Stan Komerick, Member Mr. Taylor, Annalisa Moore at the other end, and on the inner horseshoe, Phil Carvalino, Mr. Wills, and Olivia Holiday, and Paul Pulisovic, or Adam. I always get them mixed up. The two of them, I don't know what it is. They're frickin' frack. But Phil is different. Okay, so there are no deferral requests this afternoon. There are no files to be closed, so I guess we can proceed with the first application, which is item number 20, 189 Hay Avenue. It's an application for consent to sever the property into 2 undersized residential lots, and on each part so divided to be developed as the site of a new detached dwelling with an attached garage, each requiring variances to the bylaw. In this case, there are 13 variances each, provided I'm looking at the right notes. We have a planning justification letter. We have a planning email from the planner to schedule it. He advised he has concerns with the application, has been discussing with the applicant, but I do not believe we've received a planning report on the merits other than a preliminary thing that they now have going, a pre-circulation form. We also have the typical engineering comments, forestry. We have heritage with 4 conditions of approval. They want stage 1 and 2 archaeological. We have comments from Ravines and TRCA. Support from, it looks like a petition with 3 signatures from 2 addresses. And we have a petition and support from 190, 173, 165. And lastly, I think there was one more thing. Yes, urban forestry conditions 1 and 3. Okay, having said that, there's nothing else for Mr. Eagleman to do, but I'll turn the
Mr.
turn it over to him.
Mr. Chair, before we get to Mr. Eagleman, I want to bring to your attention the area resident is present on the call.
Okay, so we do have one registered speaker from 177 Hay Avenue. You can also ask, is there anyone else in the room present who wishes to speak to this application? Okay, so we have the one speaker up. You, sir.
Yes, thank you, Mr. Chair. Good afternoon again. David Eagleman, 900 The East Mall, Suite 300, Senior Planner, Design Plan Services, here on behalf of the owner. Through you, Mr. Chair, Just to clarify, I think you may have been referencing some of the materials for my next item, because I don't believe heritage staff or RNFP have commented on this application.
Sorry, I read out some of those from the next application. So this one, just to reiterate what planning is, we have a planning justification letter from yourself, and planning is looking for, well, they haven't really told us, correct? Is that part of what I read correct? That they
Through you, Mr. Chair.
had an email that he has concerns.
Yes, through you, Mr. Chair. That is it is an old email. It's, I believe, from October 2022. We have consulted extensively with planning staff on this application. I've been dealing with this file since 2020. It's a 2021 file at the committee. I have confirmed verbally and via email that planning staff do not have any concerns. The lack of a formal report expressing any concerns is a testament to that. I just haven't submitted any. I typically don't submit correspondence via email to the committee, but I assure you planning staff are satisfied.
Yeah, I can tell you that sometimes we get these email threads, which really, in my mind, shouldn't be included because it just complicates things. But so this is the right application, though, the one that has the 13 variances. I think everything I said after the petition and support from the three at 190, 173, and 165 do not apply. So there is no RNFP or TRCA or Heritage. That's on your next application.
Correct, sir, through you.
So, okay, so you're saying planning has no concern. So I guess, why don't you give us a short presentation in the time you have left of these 13 variances, including the fact that the lots are undersized and that they fit within the character of the neighborhood, et cetera.
Yes, through you, Mr. Chair. I will keep this brief.
Yep.
As far as I'm aware, and unless the neighbor on the line is here to raise objections, I'm not aware of any objections from city departments or surrounding neighbors. All the justification for the variances and the proposed consent is within my detailed justification letter, so I'm not going to go into that in detail for the sake of time. Yep. It is my professional opinion that the proposed consent meets the criteria under Section 5124 of the Planning Act, as well as Section 45.1 of the Planning Act. I find the recommended conditions from engineering, construction services, as well as transportation services to be acceptable, as well as the recommended conditions from urban forestry. And it really is a severance to create two new lots where one currently exists for two new single detached dwellings where one currently exists. The proposed consent and the new dwellings are in keeping with the existing character of the neighborhood. I did provide a lot analysis to demonstrate specifically that the frontage and area is very much in keeping with the neighborhood. The variances are in keeping with the neighborhood, and it is my opinion that this application reflects a continuing evolution of the neighborhood and reflects that already ongoing trend of development along Hay Avenue and within the broader neighborhood. And for these reasons, Mr. Chair, I believe this application meets the statutory test under the Planning Act.
Okay, thank you, Mr. Gilman. I just noticed that email, it was dated October 2022, so it is old.
Yes, sir.
So,
I have confirmed with planning staff through you, Mr. Chair, that they are satisfied.
okay, awesome. Members, any questions? Oh, questions for Mr. Eagleman before we hear from the neighbor?
I have a question.
Okay.
Just, so what is the FSI of the two properties with the basements excluded?
I will get that for you, Mr. Komoric, through you, Mr. Chair. Should have it here in my notes.
You can get it to me later. We can hear from the other deputant in the meantime.
Yeah, through you, Mr. Chair, I don't have the specific calculation. I can get it, but it does contribute to a lot of the FSI value that the variance that is being requested. So, but even with the basement included, the proposed FSI is very much in keeping with a number of approvals on the street and within the neighborhood.
So I guess my questions would be, usually community planning in these instances, what they're opposed to is the undersized lot frontage and lot area. In this case, you're given with your planning justification, you feel that it is the prevailing, meets the prevailing character and conforms with the prevailing character, it is therefore worthy of support. Even though it's pursuant to the bylaw, the allotted area and frontage do not comply and are characterized as undersized.
Through you, Mr. Chair, that is correct. As demonstrated by the lot analysis that is attached to my justification letter, a number of the lots along the street are below the maximum permitted frontage, or the maximum or the minimum required frontage and area, and this proposal will be in keeping with that existing character.
Okay, because I noticed it's not like it's just off by a little bit. It's 510 square meters down to 283 and 13.5 down to 781. So that's why I asked the question. So if no one has any more questions for you, let's hear from, Mr. Palmer.
Yeah.
Go ahead.
Sorry, I'm just looking at the covering letter that you did and clarification on a couple of variances. One of them, I think it's variance number 10, says that the rear yard deck is to be eliminated, and then variance 11 regarding side yard soft landscaping, this is to be eliminated. So does this predate the notice? Because I'm noticing on the one variance you've got 0% front yard soft landscaping. Is that because the soft landscaping is being provided in the boulevard?
Yes, thank you for that question, Mr. Palmer. That is a great question, and I would like to clarify that. The variance number 11 for Part 1 is intended to be eliminated. It is addressed in my cover letter. I believe that variance was only triggered as a result of some confusion between what the plans were showing and what the examiner was seeing on the plans. But I think the architect just didn't make it clear that the side yard was intended to be soft landscaping, but it is intended to be soft landscaping, and therefore we would like to eliminate that variance. The cover letter did come after the public notice, so that variance can be eliminated from the notice. And similarly, I'm just looking through my notes here. Give me one moment. Yes, so the variance pertaining to Part 2, the east side yard setback for the rear deck, that can be eliminated as well. I believe that was identified by the zoning examiner, again, perhaps on error, because the plans show that the east side yard setback of the rear deck for Part 2 is actually compliant with the side yard requirement. So those would be amendments to the public notice.
But for Part 2, you still need the variance for the front porch, right?
Correct.
If there's no further questions, let's hear from the neighbor on the line at 177 Hay Avenue, Nilam Shah.
Concerns.
Nilam, go ahead.
Can you hear me?
Faintly, you'll have to speak a bit louder or talk more directly into your microphone.
Okay, so I just said that I don't have any concerns.
Okay, thank you. So I guess no need for a rebuttal. So just let's floor open for some any last minute questions, or let's bring it into committee and for discussion or decision.
I have a question, Mr. Chair.
Yeah.
Did you say you're okay to remove variance 11 from Part 1 and variance 9 from Part 2? Did I hear that correctly?
So for Part 2, he's not eliminating the entire variance, only for the rear deck. So it'll say the proposed front porch will be located 0.83 meters from the west side lot line.
Through you, Mr. Chair, to clarify, so For part 2, the variance related to the rear deck and front porch, variance number 9, the variance relates to both the rear deck and the front porch. We can eliminate the portion of the variance that relates to the rear deck, but the front porch portion of the variance has to remain. And for part 1, the side yard soft landscaping variance can be eliminated entirely.
And that's variance 11.
Correct.
It's interesting looking at number 9 on the part one. Is it part 1?
No, I think if we proceeded with an approval of this, we would eliminate the last sentence,
Right.
the proposed rear deck, et cetera. We would eliminate that. Is that correct?
Through you, Mr. Chair, it would be variance number 9 for part 2. So the rear deck variance for part 1 is proposed to remain unchanged, but part 2, the part of the sentence relating to the rear deck on variance number 9 for part 2 can be eliminated, but the portion of it relating to the front porch has to remain.
So the words, the proposed rear deck will be located 1.1 meter from the east side lot line, and then it'll just say the proposed front porch will be located. So those first 10 or so words to be eliminated.
Through you, Mr. Chair, that is correct. And then for part 1, it would be the side yard soft landscaping variance entirely.
So was someone in the middle of a motion, or were we just, no?
No, we're waiting.
Oh, you
no,
were just
sorry.
asking what the, okay. I was just gonna say, it seems like it covers a lot, like number 9. They could split it up into 4 different, with respect to east, west, the deck, and the front porch. So now we're just eliminating the deck from those paragraphs. Okay, so just waiting any discussion or a motion?
I'll make a motion, but I'm going to need some help fabricating a revision to variance 9 in part 2. I find the variances, first of all, I find the consent to be appropriate and reasonable in this neighborhood. As a matter of fact, I see the 2 houses on, I think it's Simpson Avenue directly behind, look identical to what's being planned for the Hay Avenue. It almost looks like the same builder. I don't know if it is or not, doesn't matter. So I find the consent to be appropriate. And I move approval of the consent subject to engineering and construction services conditions, plus the standard conditions of consent. With respect to the variances for part 1, I'm satisfied they meet the 4 tests under the Planning Act, and I move approval with the elimination of variance 11. And I'm satisfied that the variances for part 2 meet the 4 tests under the Planning Act. And I move approval subject to an amendment to variance 9 so that it reads, help.
The proposed front porch will be located 0.83 meters from the west side lot line.
I fully accept that as a friendly amendment.
Conditions?
And
So that's my motion.
do we need to
Oh,
do that on?
so sorry.
What
Conditions.
about part?
Subject to urban forestry conditions 1 and 3. I think that's it.
ECS?
Okay. Do we not also have to revise the other paragraph 9, or is it both exactly the same?
He was only changing it for part 2.
For part 1 only.
For part 1? Awesome, okay. So we're good to go. We have a motion, seconded for that motion.
Do we need the ECS conditions, or is that stated? Sorry.
I think he's already said, you said the ECS. Yeah,
Oh, okay. I missed it. too much. I'll second.
Second that, all in favor? Unanimous approval. Thank you, Mr. Eagleman. And, okay, I think you don't have far to go. Don't go away, because the next application is, I believe, yours also. It's the one I've already erroneously stated some of the materials we had before us, but again, similar to the last one, it's a request to sever the lot and into two undersized residential lots on each side to demolish the existing dwelling and redevelop as a site of two new detached dwellings with detached garages, each requiring variance of the zoning bylaws set out, 8 variances in the first instance and 11 variants in the other. We have the engineering construction services memo. We have forestry asking for conditions 1 or a refusal. Heritage, this is the one that Heritage has the 4 conditions of approval, including a stage 1 and 2 archaeological assessment. We have Ravines TRCA, a petition with 3 signatures from 2 addresses being 27 and 23. And that's all we have. And you're the only speaker on this application, as you were on the last.
Yes. Thank you, Mr. Chair, for the last time today. Good afternoon. David Eagleman, Design Plan Services, 900 The East Mall, Suite 300. Senior planner here on behalf of the owner of the subject property. Considering the only concerns I'm aware of are from RNFP and Urban Forestry, I will provide a very brief presentation similar to the last application. I don't think I need to go through the variances and consent again because I provided a detailed justification letter with a lot analysis attached to it. So I will focus my presentation on the issues at hand, being the comments from RNFP and Urban Forestry. But ultimately, it is my opinion that the proposed consent meets the criteria under Section 5124 of the Planning Act, and similarly, the variances meet the 4 tests under Section 45(1) of the Planning Act. And regarding the application as a whole, we have consulted quite extensively with community planning staff and have made revisions to the proposal to their satisfaction. As per their report that they have issued for this application, they have no concerns or objections subject to their recommended conditions. And we find the recommended conditions from planning staff to be acceptable. I have also reviewed the report from ECS and Transportation Services and note that they expressed no objections as well and have no issues with their standard conditions that they have recommended as well. And I have also reviewed the report from Heritage Planning and find their recommended conditions to be acceptable as well. We have worked extensively also with TRCA staff on this application and on these applications. And they, as per their report as well, they have expressed no concerns or objections. We will have to continue to work with TRCA through the permit process if the committee were to approve the applications today anyway. But regardless, they have expressed no concerns or objections. And we have, as you mentioned, Mr. Chair, we have obtained signatures in support. But I will note, I believe the adjacent neighbor at 22 Daniel Street is in the audience today, and he is here as well to express support, I believe. And so to basically conclude, as far as I'm aware, the only concerns with these applications are from Urban Forestry and RNFP. They are city departments which sometimes overlap in terms of their jurisdiction. And in this case, I believe the 3 trees they are both concerned about are 3 of the same trees. One of the trees is actually 4 trees that they're referencing. And we have actually completed a natural heritage impact study as part of our consultation with and submissions to the TRCA. And that was submitted to the committee. It should be within the committee's package. And that report concludes that the proposal will have limited ecological impacts and is therefore supportable from an environmental perspective. And while we have not submitted a finalized arbor support at this time, The owner has provided me with a draft report that is also being completed by Burnside, who is the same company who completed the Natural Heritage Impact Study. And I have reviewed that draft copy of the arborist report. And as per that arborist report, only 4 of the 43 trees inventoried on the subject property have been identified for removal. And another 4 trees have been identified for injury, and the remaining 35 trees on the subject property are proposed to be preserved. And based on the recommendations within the draft arborist report I've reviewed, only one of the trees of concern, as per both RNFP and urban forestry, which again is actually 4 Siberian elm trees, is proposed to be removed. And the Natural Heritage Impact Study notes those are invasive species. We will have to get permits for any injuries or removals, and as part of that permit process, any required tree replantings or cash in lieu will have to be provided. So those are my submissions, Mr. Chair and committee. I would like for the committee to approve the applications today, and I am open to any questions at this time.
Okay, and you're okay with the planning recommended conditions of approval for the night sky compliant and the construct as illustrated with respect to length, depth, side yard, and east side? I don't know if you said that or not.
Through you, Mr. Chair, we are acceptable to all the recommended conditions, including planning, as well as any forestry conditions that should be imposed should the committee choose to approve the applications.
Okay.
There are
Any
also the
questions?
heritage ones.
We are acceptable to those as well.
Yes, archaeological. Okay, any questions for Mr. Eagleman? Okay, so we can bring it into committee, or there's no other speaker. Are there any speakers in the audience? There is a speaker in the audience who said, perhaps more than one? Whether it's in favor or against?
Yeah, I believe it's just the neighbor at 22. He's the only immediately adjacent
Wow,
neighbor because
okay.
this is a corner lot. Can you confirm you're in support of the application?
Okay, so we need him to come to the podium, just state his name and for it to be part of it.
You want to
Yeah.
be on record if you,
Okay. We don't swear people in.
Hey, yeah, Mike Bajera, 22 Daniel Street, so the immediate neighbor. Full support for the
Okay.
proposal.
Very nice for you to come out, and hope you've enjoyed yourself.
So you're in the nice big modern house right beside this lot.
Wonderful. Okay, so any questions, or is someone ready for a motion?
It's ripe for development.
Sorry, Laura had her mic on. I thought she was going for it. If not,
Sorry.
I'm satisfied that the conditions for consent have been met under the Planning Act, and also that the variances are minor and meet the 4 tests. I would like to move approval, subject to forestry condition 1 and forestry condition / RNFP condition 3, planning 2 conditions, and for the bird friendly that we discussed at the previous part of the hearing, heritage 4 conditions, and the usual ECS conditions of severance. That's my motion.
Okay, thank you. Seconder for Mr. Komarik's motion. Mr. Palmer? Okay, any discussion? No, all in favor? You have unanimous approval. Thank you. And I think you had 4 up, only 3 or 4? 3 is a hat trick, so 4 is hitting for the cycle. Okay, we'll see you again. Thank you. Okay, our next application is item 23 A, B, and C, 46 LUNNESS Road. Again, it's consent to sever the property. into
Mr.
2
Chair?
sorry,
undersized
we're on
lots.
Mr. Chair?
23
Yes.
Roseland.
Item number
sorry,
22.
I jumped ahead one. Okay, page break. Okay, so 23 Roseland Drive, parts 1 and part 2. And this is an application in consent to sever once again the property into 2 undersized lots to demolish the existing dwelling and to redevelop the site as the site of each side, new detached dwelling with attached garage, requiring variances to the zoning bylaw. In this case, 7 variances in each case. We have a copy of the site-specific zoning bylaw, cover letter, photos, arborist report, engineering construction services. Planning has filled out a pre-circulation consent form to schedule the application, but I don't think we've received anything after that, or we'll hear about that. We have Urban Forestry who wants us to deny or impose condition 1, and we have one other, we have the photos we have are of the neighboring houses in the area. We also have an opposition letter from 21 with concerns regarding variances 5 and 7, the side yards and the roof eaves. And the speaker for this application, or speakers, is Eddie Perez.
Hello, good afternoon, Chairman and committee members. I'm Eddie Perez. I'm here on behalf of the owners. As you said, we're proposing to sever a lot. The lot is 7.62 meters each. They're very common in the area, as per the pictures that I've attached. You can put them up on the screen if you like. And for the house right beside, which got approved, it's it got approved at a little over 40%, which is 99.81 times. We're asking for 99.62. We're asking for 71 times the area of the lot. The house next door got approved at 0.89 or 221. And also they got approved as for the height. It is a flat roof. They got approved at 907. We're asking for 927, and it's also, that's to the top of the pitched roof, so we're much lower. So what we're proposing is in keeping with the area and very minor in nature, and I feel that it meets the 4 tests. Thank you very much. If you have any questions, be happy to answer them.
Okay, thank you, Mr. Perez. Thank you, Mr. Perez. Any questions for Mr. Perez?
Question. I believe a planning preliminary report stated that they felt that the variances do not meet the 4 tests. Can you address that?
Yeah, we took care of that. We eliminated the length variance. We reduced the house in width. So variants were a little bit different when we first applied. And now the variants that went out reflect what's being proposed, and planning is on board. They just said they wouldn't comment on it, but they are on board now.
But if they're, so maybe this is a question for staff. If they're giving us a negative recommendation, shouldn't we get at least a correspondence saying that they're now withdrawing that, or that they're now okay with it?
Yes, that would be
Yeah,
our
they're okay 'cause-
expectation.
I guess June 13th, he said, we're okay, comfortable with scheduling.
But it doesn't say that.
And I guess you'd assume other comments would come if they were gonna have comments, but it seems it's a bit of a pattern that they just don't comment.
So we're kind of reading into their thoughts a little bit.
Yeah, well, the question is, where do you read, like, is that something we're supposed to even be, sort of emails back? In June 13th, he normally says comfortable in scheduling and further comments may be forthcoming or will be
The
forthcoming.
initial staff report is negative. And so I would like something on writing saying that this, this is no longer negative.
Sorry, where is it now? I didn't see a staff report.
Well, it's not a staff report, it's that
Oh, I see, the pre-planning
yeah,
review.
yeah, I'm trying to find where that is, here it is. So it's, where they tick off which the form letter, right?
Yeah.
So the form letter they've ticked off as number 2, which is basically the minor variances do not pass the 4 tests. And
That was back in May. Mr. Perez is saying you made some changes, you shortened.
Yeah, you can read the, sorry to interrupt. You can read my cover letter, which describes what we did. And then I got in an email that they were on board. They said they wouldn't comment on it. They were okay with it.
Yeah, okay.
As it was. as
no,
it
and,
was presented.
and I believe you, and my comment is really more that it would be nice to have that email for us to read as well.
Yeah, that's, as a practice directive, it's on the record, it would probably be in this situation when they express concern in the pre-circulation form, that they at least you know, in this case, we can rely on Mr. Perez, a very highly respected long-term agent before this committee, who I would take him at his word, but it's probably good form rather than to start wondering and taking people that they, in the circumstances where they express some concern in the pre-position form, at least a short email, and we don't need a whole report, at least an email to address Mr. Cormac's very real concerns as to what community planning. Yeah, well, but community plannings, we're rather than have to take the app agent and say, yeah, I took off the length and they're okay, that you actually get that out of the word of the community planner who wrote the first report and said he has concerns. You know, you don't get a second chance at this stuff, right? So it's a little bit of effort that potentially avoids a big misunderstanding and a unintended precedent. So not a lot of effort. Thank you, Mr. Comeric, for that suggestion. Okay, so having said that, are we?
There was also an objection letter that was saying that variances 5 and 7 are too close to the property line. Has that been addressed, or can you comment on that?
Yeah, as per being close on the neighboring, both neighboring sides, we comply with the eaves. We don't comply with the eaves in the middle of the two houses, which is very common, and we're only 2 centimeters off, which is 0.28.
Okay,
On
so
the side
you're,
of the neighbors, we
so
have
you're
more than
complying with the
50,
abutting lots, not with the,
with the abutting neighbors, where our eaves, they comply, and they're over what we're allowed. You're at 0.3, we have 0.5 something, so we're okay on both sides. Just in between the two houses, we don't comply with the eaves. And
Understood.
the 0.3 is very common in, when we sever lots, a 25-foot lot or 7.62. It's very common practice, and it's in keeping with the area. And like I said,
And at
Yeah.
least it shows
Okay,
if you're
thank you.
gonna, rather than inconveniencing the flanking two neighbors, you do it in the internal between the two newly created lots. At least the people who buy those or occupy those knows what they're getting into, and rather than to impose it on other neighbors. So that's the way to go. Okay, so are we in the middle of motion or waiting for a motion after that clarification?
no.
No motions yet, Mr. Chair.
Go for it.
Yes, first of all, with respect to the consent, I'm satisfied that the lot pattern is consistent with the immediate context. I counted up at least a dozen lots of this size in terms of lot area and frontage, so I think it's quite in keeping with the neighborhood in which it exists. I move approval of the consent subject to engineering and construction services conditions and the standard conditions of consent. With respect to the variances for both parts 1 and 2, I find them to be in keeping with the 4 tests under the Planning Act, and I move approval of the variances for both parts 1 and 2, subject to urban forestry condition number 1. And that would be it.
Okay, thank you, Mr. Taylor. Seconder for Mr. Taylor's motion. Laura Alderson, thank you. All in favor? Unanimous approval. Thank you, Mr. Perez. I think you had 2 or 3 applications today.
Thank
Okay.
you. Have a nice
See you
evening.
again. Be well. Okay, 2 more applications. The next one is the one I tried to jump the gun on last time until I was corrected. 23 A, B, and C, 46 LUNNESS Road. We have a revised notice for the agenda. This is again consent to sever the property into 2 undersized lots and demolish the existing dwelling and redevelop each side as a site of a new detached dwellings with detached garages, each requiring 11, there were 11, now 10 variances, 5 of which of those have been revised. We have a cover letter, several pages long. We have supporting materials presentation with an as-of-right site plan. We have an arborist report. Planning wants a condition of approval regarding the FSI. We have the engineering construction services. We have heritage and TPPR. They're looking for conditions 3 and 4 in the urban forestry consolidated memo. two objection letters from 491 Valermo and 47 and 44 and 49 LUNNESS, or they're three addresses with one letter. And I guess that's all we have.
Mr. Chair, I'd like to bring to your attention, the area resident is present on the call. We also had a late minute registrant. They're also on the call. Now internally, we do have their name, but of course we'll have them introduce
Is there
themselves.
someone here in the room who's?
No, sir, they joined virtually.
Oh, okay. So we have Franco Romano as the agent for presentation, then Jason DeLuca at 47 across the street.
And then a third area resident, Deep Trivedi, is also participating.
Do we know address or?
I think 45, Mr. Chair.
Okay, Dean Trebetti.
Correct, 45 LUNNESS.
Okay, so welcome, Mr. Romano. It's been a while.
Good afternoon, Mr. Chairman. Franco Romano here on behalf of the owner. Thank you kindly for that introduction.
Okay.
So I do have revisions to be made, and I understand that you do have a revision sheet for each of the two lots, and
Yes.
I'm happy to, I've gone over those revision sheets, and I am in concurrence that they accurately reflect the revisions. I'm happy to walk through them briefly. So what we have before us for both applications is the elimination of the building length variance, a reduction of the lot coverage variance to 37%, a reduction in the gross floor area to 1.02 times the area of the lot. That is reflective of and inclusive of the basement. And we have building height reduction to 9.01 meters, a wall height reduction to 8.6 meters, and the rear platform is being reduced to 10 square meters, and that rear platform is actually off of the ground floor. And I'll just start off on that jumping point. The basement is being considered by the zone examiner as a first floor, which is why they've included the all three levels of basement, first and second floor as part of gross floor area, and which is after we've worked with staff, why staff is recommending a condition of approval that the development be constructed substantially in accordance with the architectural plans as it relates to floor space index or gross floor area. And that is to ensure that the 1.02 reflects the 0.74 over 2 floors above grade. If staff could kindly, Olivia, if you can kindly bring up my presentation slide, please. In terms of, that's terrific, thank you. In terms of the lot fabric, upon LUNNESS Road itself, there's approximately 48% of properties that have a comparable lot frontage. 44% of the properties on LUNNESS have lot frontage of 7.62 meters or smaller, and the lot sizes range from 6.8 meters to about 20 meters for some non-residential. It's included on LUNNESS. Lot areas have similar characteristics along LUNNESS, and the neighborhood itself, which is just east of Brown's Line, has a similar character. So the proposal in terms of lot sizes respects and reinforces the existing lot fabric. In terms of the dwellings themselves, you'll see on the right-hand side that there's a series of photographs that show some of the older and some of the more recent construction that's occurring. It is a neighborhood in transition. Some of the dwellings that are being constructed, including 2 floors and 2 floors above a garage in both a sloped and flat roof condition, and flat roof is shown in some of the upper photographs in both a larger lot as well as a lot that is comparable to what's being proposed. On the site plan, you'll see the as-of-right building envelope in a pink box, and the proposal fits within that except for the 2 side yard setbacks at 0.91 meters to the outside. You'll see that that is in keeping with what's occurring on the street and in the neighborhood, the proposed side yard setbacks, as well as the other performance standards. Lot coverage is fairly modest, and building height is to that former 1979 zoning bylaw. The current zoning bylaw permits different and taller heights, which are not at variance in relation to the proposal. So I've read all of the comments. All of the conditions of approval are satisfactory. The urban forestry comments relating to providing additional information, I noticed that their memorandum does not refer to the arborist report that was filed and is on file, and that arborist report shows that there is a negligible interference with a tree protection zone for those two neighboring trees. So subject to any questions, I submit that what's being proposed is indeed in keeping with the character of the neighborhood and represents good planning. Thank you, Mr. Chairman.
Thank you, Mr. Romano. Right on time. Any questions for Mr. Romano before we hear from the two neighbors? Okay, in that case, I guess the first neighbor we'll hear from is Jason DeLuca at 47 LUNNESS Road. And we have a letter, I guess, filed on behalf of three neighbors, 47, 44, and 49. Together, they've signed that letter together. And as well, we have that separate letter for 491 Valermo.
Hello.
Hello.
Hi. Hello, Jason DeLuca here. I'm a resident who lives across the street. I just want to say off the bat, I'm not against intensification. I'm not, in principle, against splitting the lot to create more housing. That's fine. I think it, generally speaking, it looks like it fits in the character. There's other projects like this. My concern is, as I stated in the letter, is the removal of the tree, that really nice mature tree that was located in the public right-of-way on the city side, street facing, in front of the house. And it was a really nice tree. It added to the character of the area. I can even share a screen. I have some kind of visual showing the street. And there, yeah, you're showing some pictures there. That's from 2019. There's even some more recent photos I can show, even on the date of the removal, showing the maturity of it. It's unfortunate that it was removed in the way that it was, without a permit. I spoke with urban forestry. I understood that that was kind of dealt with through some type of fine or something. And looking at their memo and talking to them, I understand that they put in a condition, they requested deferral of the application, something like that. You'll have the memo in front of you from urban forestry, stating that 2 new trees would have to be compensated for, given that there's 2 lots. That's my understanding of what urban forestry is saying. Now, I guess the reason why I thought it'd be a good idea to talk is because my concern would be that a fee is paid, but then no new trees are planted here. And I think it's in the best interest of this street that the money be put towards 2 new trees on the new lots. It doesn't really help us if the trees are planted elsewhere. And I think that the requirement that the trees be planted here on these lots, it relates to the Toronto official plan. If you look at under the Chapter 5 neighborhoods, Chapter 4.1 neighborhoods development criteria, Policy 5H, continuation of special landscape or build form features that contribute to the unique physical character of the geographic neighborhood. That if you see the street, and I can even share like a street view right now if you wanted to, but you can imagine that it's a tree-lined street, and it just so happens that there's a tree planted in front of every house. And it just adds to the pedestrian-friendly nature of the neighborhood. I think that it shows kind of good faith and sort of good intentions on behalf of the developer if they were to plant those 2 new trees, or the city ensures that they're planted. It just, it doesn't feel amazing when a developer comes and, you're supportive of new housing. You want to see more houses being built, but then, things like that aren't being really respected in the way that you would hope. It's not really sending the right message. So one thing, maybe a suggestion would be, is that perhaps, the arborist report be updated to demonstrate that trees could be accommodated within the new landscaped area adjacent to the driveways. Because I was talking to urban forestry staff, it's not 100% they can't guarantee that a new tree could be accommodated within the new lawns. They think that it probably could be, but is there a way to just sort of make sure that the new trees are prioritized to be located on these new lots?
We'll certainly raise that with Mr. Romano, who is a very reputable agent. I can tell you that I'm happy, Mr. DeLuca, you've come forward. If I was in your position living there and the tree I'm looking at between me and the house across the street gets unceremoniously cut down, I'm not sure, you said 2019? So for sure, if the area...
Oh, no, sorry. 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 I don't mean to disrupt you. Go ahead.
So when did that tree get taken? Was by the
something.
current owner or former owner? I think you said the current owner.
It occurred on July 28th, 2022.
Okay.
And just because I have a security camera on the front of my house, so I had the exact date.
So for sure, I would expect Mr. Ronan to at least confirm, if space allows, that there should be at least 2 new city trees. You're not allowed to just go and cut down city trees. And it's...
No, it doesn't belong to anybody.
Did you not call 311 when that happened, or no one's done anything?
I called 311, yes. I called 311.
Yeah. Okay. Anyway, we'll hear for sure from Mr. Romano on that. I'm sure he did not condone that. He probably wasn't on the file at that point. You said it was done shortly after the title change to the property. But for sure, we're very happy you raised that issue. And we'll hear from we have one other speaker, but as far as the actual development, the 2 lots, the size of the 2 new houses, you have no objection to that?
Yeah, no, it's fine. Okay. I'm glad that an additional family can make their home on this beautiful street. Let's just make sure it stays beautiful.
2 nice trees in front of it, too. And maybe some extra money put into landscaping. Okay, thank you, sir. Does anyone have any questions for Mr. DeLuca or comments? If not, let's hear from, you said it was Dean?
Mr. Chair, Deep Travardi.
Deep Travardi. Okay, and you have the spelling for the record and all of that?
Yes, Mr. Chair.
That's from 45 next door to Mr. DeLuca.
That's correct. My name is Deep. It's a pleasure to be on the call. I have mainly joined to echo and underscore the comments that my neighbor Jason has made. So I certainly am in full endorsement of that. It was a rather shocking discovery for me, not because I have a security camera on my front, but the surreptitious nature of the tree removal by somebody who is a developer and has developed properties in our neighborhood, in my honest opinion, should know better. And so we feel it would be restoring the character of the neighborhood, which has been eroded. And otherwise, I echo all of the sentiments raised by Jason.
Okay. Again, though, sir, you have no issue with the actual build form and the splitting of the lot?
Not on the splitting of the lot. I as well look forward to an additional family joining our wonderful neighborhood and street. I do have a question, if you may indulge me, since I don't have a strong background in architectural drafts. I noticed that the concrete porches are extending beyond the setback. Is that a routine expectation of concrete front porches to extend beyond the front setback? Or is this an adjustment that is outside the character of what's normally considered?
Okay, we'll let Mr. Romano respond to that. Okay, so does anyone have any questions for Deep? Okay, if not, we'll let Mr. Romano respond to the neighbor's concerns, which fortunately for him are not related to the built form. But what's going on with your client and this tree, and what's going to be done to make up for that? Because it's unacceptable, in my view, that these neighbors should have to have the greenery in between them and the houses removed. So, were you aware of this? And again, it should be reflected in the arborist report, which I'm advised it does not. So back to you, Mr. Romano.
Yes, thank you. Thank you kindly, Mr. Chairman. So the tree removal in the front came as news to me after I read that one of the first letters that were posted on the AIC. And the owner provided to me an explanation that they had confirmed with urban forestry the additional plantings that would occur and the fine that was incurred because of that. I really don't have a lot of information relating to why the tree was cut down or how the tree was cut down. And it's not on the arborist report, probably because the arborist, when they went out on site, only was looking at trees that existed at the time the report was being prepared.
So
What I
is there enough,
will-
is there enough room for 2 trees, a tree in front of each of these 2 new houses?
Yes, there is, sir. But I wanna, you know, that was going to be the next point. I was going to talk to the questions, I guess, and the queries relating to trees. So urban forestry routinely requires of applicants, whether it's a single property or a severance or even a larger development, to where there is no street tree in front of the land subject to the development, a cash in lieu of planting a tree, because the city will not allow a private property owner to plant a tree in the city boulevard, even though it happens from time to time. So that's why they take the funds and then they distribute those funds throughout the neighborhood. So it's not guaranteed that urban forestry would plant trees in front of these properties based on the funds that they would receive from any approval that the committee may grant to this application. But that is something that is within urban forestry's mandate to do. They could, but it's not guaranteed. And the reason why they would say that there may not be enough room is because of underground utilities, not because of the planting or the viability of planting space in the front. So the condition of approval for the cash in lieu of planting a tree will allow for trees to be planted by urban forestry where urban forestry deems it's fit to do so. I am looking to recommend to the Committee of Adjustment that should the committee grant approval of each of the minor variance applications, that they can add, and I would recommend that they should add a condition that the owner shall plant 1 new native tree on private property within the front yard. And if that is a condition that's imposed by the committee attached to each minor variance approval, assuming an approval gets granted, that would require the owner to plant such a tree as a condition associated with the construction of a dwelling upon each lot, and that would ensure that there would be a tree in front of each dwelling, regardless of whether urban forestry decides in future to use the funds to plant a tree in the boulevard. In terms of the question relating to the concrete porch, the site plan shows that the porch is, there's an inset to the front wall of the porch. So that's a bit of a staggered condition. And it is common for a porch and stairs to project from the front wall. And that projection from the front wall is permitted to extend in front of the front yard setback line. And that's a common condition in pretty much everybody that has a house or a dwelling or that has a front porch and stairs. They project into the front yard setback. Subject to any questions, I think those were the points that were, unless I missed something, the points that were raised, Mr. Chairman. Thank you.
Okay, thank you, Mr. Romano. You read my mind because when you first gave your story about how, you know, the city decides where it doesn't mean it's going to go on the front. There's other issues, city utilities, buried cables, whatever. So I was going to say, come on, Mr. Romano, you're one of the smartest planners that could appear here. So thank you for coming up with that suggestion. I was going to ask you, how do we ensure? So that would be that they, as a condition of approval, this committee would impose that they plant 1 new native tree on the front yard, on the non-city part of the road allowance, on their own property in the front yard, correct?
Yes, sir.
So that would be on their property. Is it possible, though, that once they do that, they wouldn't be room for a city tree, although then that obviates the need for it because they're gonna do it just inside their portion of the property in the front yard? So that
It
basically
wouldn't.
takes it away from
It
urban
wouldn't
forestry.
obviate.
Right, it takes away
Yeah, it
from urban
wouldn't
forestry
obviate
because
the-
they're gonna put the tree in as a condition of approval to getting the consent and the severance from this committee. And that will supersede, once the city sees there's a tree, there won't be any room for a city tree on the city boulevard. But I don't think that's a problem.
That's,
No,
I don't think that's what I
wouldn't,
was hearing
wouldn't-
from Mr. Romano. I think I was hearing that we impose condition number 3, which is cash in lieu. Is that right, Mr.
Yes.
Romano? Thank you.
Yes, and I don't believe that there's a lack of space in the boulevard to plant a tree with a tree on private property in the front yard as well. There's plenty of space. Like, this is not
Okay,
a
so it's
substandard city
both.
boulevard. It's a big boulevard. Yeah, and I would impress upon, urban forestry is going to act based on. It's almost like the city has their capital infrastructure improvements, and they'll get to certain neighborhoods at a certain time based on their budgeting and how they identify capital improvements. So it's really incumbent upon residents and neighbors to be on and approach urban forestry to make sure that they are planting trees on their street and in the neighborhood. And I think the residents across the street do have a voice with urban forestry, and I'm sure that they'll be able to accommodate that tree planting in front of these sites. But my recommendation to the committee is that we add a condition to each minor variance application to require a tree be planted in the front yard in private property.
Okay, thank you. Okay, so any other questions, or some ready to make a motion?
I have one question of Mr. Romano. Mr. Romano, in your opening remarks, you talked about the condition requested by community planning. And I think I heard you say that you would be okay with an expanded condition. Right now, it only speaks to floor space index. Did you say that you would be okay with adding something else or not?
Through you, Mr. Chairman, I don't think I expanded upon it, but I don't have any difficulty with saying that with that condition saying that the proposed development shall be constructed in substantial accordance with the drawings held on file with the Committee of Adjustment.
Okay, and it goes on to say, as it relates to floor space index only.
Yeah, we usually specify what
Yeah.
concern with.
So you're okay with that?
Yep.
Great.
Okay, so if no more questions, we'll await a motion.
Okay, I find the lot pattern to be consistent and appropriate. Would therefore like to move approval of the consent subject to the usual ECS conditions. Would also like to move approval of the variances, which I find to be meeting of the 4 tests, subject to the planning condition of as illustrated in the plans of July the 12th as it relates to FSI. Also subject to the 2 heritage planning conditions. And furthermore, subject to forestry condition 3 and subject to the owner undertaking to plant a single tree in the front of each lot on the private property.
So as just a new native tree, I guess, within the front, I think Mr. Romano.
Yeah, as elaborated by Mr. Romano.
Okay, thank you for that motion, Mr. Kamarick. Do you have a seconder for that?
I'd like to propose a friendly amendment. We also have a condition requested by Tree Protection and Plan Review for condition 2. Yeah, there it is, TPPR.
Right. Did also not see conditions 3 and 4 in the consolidated memo? Or what-
4 is to
The
defer.
consolidated memo from Urban Forestry said 3 and 4.
Right.
A separate freestanding memo from TPPR dated July 11th requested condition 2.
Yeah, so by all means, I would add the TPR condition.
I'd be happy to second the motion on that basis.
Wonderful. Okay, so we have a motion, friendly amendment, seconded. All in favor? Okay, you have unanimous approval, Mr. Romano.
Thank you kindly for that deliberation and appreciate it. And thanks to the neighbors too for participating. Appreciate it.
Correct, thank you. Okay, so we can move on to our last application of the afternoon, 35 King George's Road. This is deferred from the April 13, 2023 hearing. It's for a detached dwelling with an attached garage and a new pool cabana in the rear yard. We have the minutes of the previous hearing. It was in order to consult with planning and obtain a new zoning notice. That was the purpose of the deferral. Planning has now given us conditions of approval to construct as illustrated with respect to the building length. Forestry has weighed in. They want us to deny variance 6, or alternatively, urban forestry condition 1 to permit to injure a city-owned tree. I'd note that there was nothing on the consolidated memo on this application. We have no concerns from transportation. We have a petition from 356 Prince Edward Drive, a couple of others on King George. We have opposition from 39 and 37, and 358 Prince Edward Drive. He's given us a 6-page letter with photos and diagrams. So I believe we do have some, yeah, planning, I did say had a condition on the building length, construct as illustrated. I had said that. And that's it. And the speaker we have 2 is Addison Milne Price, the agent for the applicant, and as well as the neighbor at 37 King George's Road.
Mr. Chair and members, I'd like to bring to your attention, we did have a second neighbor to speak for this file. They were put in the wrong spot on the file. So they were on item number 18, and the area resident is Christine Sanding at 358 Prince Edward.
358, okay, and I think we have a letter.
Like I said, item number 18.
We have a letter from that address as one of the opposition letters. And I believe the applicant, the agent is here in person standing at the podium.
Mr. Chair, all 3 people are present for this item.
As well as Carol Arundel and Christine, didn't catch the last name as well. Okay, very good, sir. So go ahead and let's have a presentation as for our last application of the afternoon.
Thank you very much. Is it on now? Perfect. Thank you. Before I speak about the particulars of this application, I'll just state for the record, my name is Addison Milne Price. I'm a planner at Design Plan Services located at 900 the East Mall, Suite 300, agent on behalf of the owner. I'd like to address the changes that were made during the deferral period that resulted in the application before you now. I'll note that planning staff is satisfied with the changes we made to the proposal. Firstly, I'd like to address the apparent increase in building length and depth. The original zoning review and public notice did not include the below-grade portion of the house in the building length or depth. During the deferral period, we had the zoning examiner correct this, which is why the building length and depth variance increased, despite the above-ground portions of the building being reduced. Previously, the application proposed an exterior main wall, 23.3 meters in length along the west side, and now, including the one-story garage, the west wall has been reduced to a length of 20.27 meters. The two-story portion of this wall is now just over 19 meters in length. I'll note as well, the variance previously required for the cabana in the rear yard was eliminated. And the final change was a reduction in the total proposed GFA, and that was a result of excluding non-habitable space in the attic. The proposed GFA now is 150 square meters plus 40% of the lot area, which translates to an FSI of 0.57 times the lot area, if you're more familiar with that configuration. The proposed dwelling will also have a lot coverage of 27%, which is well in line with the permitted lot coverage of 33% on the lot. Further, there are several approvals for FSI and GFA in this area by this committee that demonstrate the proposed GFA is in keeping with the existing physical character. I can get to those decisions if requested, but I'll move along now for the sake of time. Variance 2 is for the side yard setback to the east side. The side yard setback proposed represents a difference of 13 centimeters from a setback that's permitted. And I'll also note that the proposed east side yard setback is slightly larger than the existing setback of the neighboring building. I'll speak to the next two variances, building length and depth, together in the interest of time. Note that as I previously mentioned, the large portion of these variances are a result of below-grade portions of the dwelling, which have no massing impact. The two-story wall proposed on the west side of the lot line is proposed to be 19 meters and 7 centimeters in length. Due to the curve along this section of King George's Road, the front lot line is not parallel to the front main wall of the dwellings, but at an angle. And this has resulted in an atypical development pattern where the front of each house is not in line with its neighbor, and the front and rear yard of each property is next to the side main wall of each neighbor's dwelling. This situation is true for any dwelling proposed here on this lot, whether the build requires a variance or not. Considering this, I want to also bring your attention to the east side of the dwelling on the site plan, which has a length of 17 meters and 7 centimeters. And note as well that this eastern portion of the dwelling's rear wall is compliant with the building depth requirement. In other words, a two-story rear wall would be permitted as of right in a location behind the one-story breakfast nook on the plans. Remember, building depth is measured from the required front yard setback to the rear main wall, and the front yard setback is on an angle, which means the requirement for building depth is also a line on an angle. This line runs parallel to the front lot line and starts at the top right corner of the patio on the site plan there. This means that following this line, it's only a small portion of the western sidewall that requires relief from the depth requirement. As such, most of the above-grade rear main wall is actually in a location that is compliant with the building depth requirement. Therefore, it's my opinion the proposed length and depth would have little to no impact on the adjacent dwellings further than what would be felt from an as-of-right dwelling. In terms of variance 5, building height, we're asking for 30 centimeters or about 1 foot on the overall height. The proposed dwelling will appear as a two-story dwelling with a sloped roof, which is consistent with the existing pattern of dwellings along King George's Road. It's also similar to the existing dwelling on the lot. Now, the final variance for driveway width was noted by Urban Forestry that they had concern. However, this variance is largely a result of the interior layout of the dwelling. In the zoning bylaw, the width requirement for driveways is based on several factors, but in this case, it's based on the width of the parking space behind the main wall. Since there are garage walls on either side of the proposed parking space in the garage, the standard minimum parking space width of 2.6 is increased by 0.3 meters on both sides, which brings us to the total of 3.2. However, if the parking space were to be increased, the minimum driveway width maximum would increase alongside it up to a maximum of 6 meters. As such, a larger driveway could be permitted on this lot in the same location with no variance required. I'll also note that the arborist report prepared for this application indicates that the city tree to be removed is in very poor condition. That concludes my presentation.
Mr. Chair, your mic.
Yeah, thank you for that explanation. Went a little over, but there was some complications. And community planning backs up in their minimum last paragraph, the explanation of the length and depth variances, and most of it is below grade. And then the breakfast nook follows the curvature, so they seem to be fine and just want to impose that condition to keep your client honest. Any questions for Mr. Milne-Price? If not, we'll hear from the two neighbors. Okay, so the first neighbor is Carol Arundel at 37 King George's Road, right next door.
Good afternoon.
Welcome.
So, I am here in opposition to the
I
variances.
just need you to state your name. And
Oh, sorry, Carol Arundel, live at 37 King George's Road, and I'm opposing the development application along with the other co-property owner, Paul Burton. I am opposing the variances as set out in my letter. You referred to the length of the letter because I do go into some depth. I would appreciate if you could bring up some of the photos that I put in. The lot, as you know, is almost a double lot, or it is a double lot. It could be severed if there was access to the back part and a new property built on it. So when we're talking about the percentage of a lot area for the square foot allowance, it is incredibly different from any of the other properties in the neighborhood, much larger. The agent just talked about it being a two-story structure. In fact, on that side that you see right there, if you look at the plans, you will see that there is a third-story window. The window is more than 8 feet in width. It starts at the second floor, continues up to the third floor, and there is a clear in the line of that, the building wall continues up to the third floor. So that's not exactly correct. I'm not going to go through all of my objections, but they're related. The length is related to the square foot area. The height is only 11 inches. You know, that would be knocking off 3 inches per floor to bring it to fit. I don't understand some of these variances, why they have to be variances when you've got such large ceilings. 3 inches is nothing. The driveway with the suburban style garage sticking forward and the two Tuscan columns, I know you can't talk about design, but honestly, they don't fit. We don't need a driveway variance according to the arborist report, which came the day after we needed to do our submissions. It's connected to the tree, so I would like to object to the request for the removal of the tree. The date, there were 2 arborist reports posted, July 13th and 14th. The trees, there are 2 in the front. They both need to be protected. I hope they both will, not just the one big one that you saw in the application. I'd like to comment very briefly on the support letters. Most of the signatures are from blocks away. One of them is from a house, I'm sure, that came forward to you for variance approval. And I went by today, I've been by a few times, but to look at pictures. That house, yes, has a greater variance in terms of square footage. It's much bigger than other houses in the neighborhood, but it ends more or less where the neighboring houses end. This one gives me almost 3-story, or partially 3-story, but definitely 2. Brick wall with multiple windows. And I have 11 feet of space where my shed is, so I would have to then go to the expense of removing my shed to get a little bit of break. Now, I ask you to identify one house which has to live in a situation like this. And if you could bring up the pictures where I compared the 2, I put circles around the space. This is not normal. So the variance, yes, the houses are set back, and yes, I'm fine with this, and I'm fine with some extension. But to take my entire lot is unreasonable and unfair. The example of the house that I'm sure the agent will talk about is number 77. They are much bigger, they have extended past, but there's got to be 30 feet of garden after that. They also have a garage at the back of house. They have a side driveway, so they are not abutting and blocking the neighbor's windows on the east side. I'm on the west side, but I'm just saying that it's a very different type of development which took into account the neighborhood and the issues related to the neighbors. In this case, the development has completely given me a brick wall with a lot of windows directly looking into my garden, and on the other side is blocking within 5 feet all the other person's windows. So, we have to be fair here. Some of the other proponents that have agreed with this live multiple blocks away. One of them lives next to number 77. I know they objected to number 77. Another one lives at 11. That's 2 or 3 blocks away on the other side. The people that live opposite on King George's have not been in Toronto much, and I'm not sure how they signed, but because they weren't here that day. But we have what do you call it, an island. And so they're in a big house with the island with 2.5 lanes plus an island. So all they're going to do is see the 2 columns and the front-facing garage. So they're not being overshadowed or bothered in any way. The people behind on Prince Edward who did support in April, I understand, have very big concerns, but they have not objected, so I can't speak on their behalf. But otherwise, it's the 2 of us, and it's because of the way the lots are situated. And frankly, there was no consideration given to either of us, in my opinion, but I'm here to speak to me. No consideration given to me. I don't know how anybody could expect that this would be acceptable.
Thank you. One thing, yeah, very good point you brought up is it is a huge lot. So to come and have a coverage issue, you know, the lots related to the houses, where does that fit in? Because they're using that sort of L-shaped piece, all of the land.
Yes.
It's all in the front, though. It's not distributed among that, I guess.
Yeah.
So certainly Mr. Romano will address that. Okay, does anyone have any questions for the neighbor at 37 next door? And if not, we'll hear from the other neighbor at 358, which is, I guess, down several houses.
No, I'm right next door. I'm on
Oh,
the
sorry,
other
it
side.
moves that way. I was
Yeah,
looking.
no, I'm on the east
352,
side.
Right, the other
Yes.
side next
And
to the
just
L
for,
shape.
and just for the record, I did send a 3-page letter of
Okay.
objection. Okay, good.
So
No,
you're
I-
358. So
yes,
looking
I'm
at
on the east side of
356. You're
30.
right
Yes,
beside.
yes, I am. And my name's Christine Sandig, 358 Prince Edward Drive, and I am going to speak to the impact of all the variances because they all overlapped. First of all, I strongly object to the variances, and it does have a huge impact on me, not a little one and not negligible. First of all, their building is going to be everything, most of it on my side of the property, the 10-foot cabana, which will block my backyard. Sorry, I'm nervous. The glass breakfast nook have no light or privacy. They have 8 windows looking in on my side. Currently, we have a driveway between us. So they're tearing it down and they're building much closer to me. And so instead of the 1.5 setback, they now want to be 6 inches even closer. And they want to put up trees, which I hope are on their property. I'm just going to say that it's a huge impact being so close to me. And just even 6 inches closer, I'm sorry, but I have an 84-year-old house. All of that digging and length and destruction is undoubtedly going to affect my property taxes. It's also going to affect my tree because I have a tree and I was told, oh, we'll just put a fence around it, which is clearly it's a large tree. I'm sorry I didn't take a picture. And speaking of trees, I also agree with my neighbor on the other side that with the arborist and forestry report that the tree in front of the property 35 King George should stay. I agree with the forestry impact. Everything is affecting me in terms of the height, the windows, and everything alongside. Like there's no privacy, there's everything is just being built up, and I really find it's going to be a huge impact. So some of those variances, you know, it might seem minor to you, but to me, it's like even more encroachment. And I also think there's no consideration for either of the neighbors, and as well the garage. It is not in keeping with the property, with any of the driveways or the garages in the neighborhood. It's completely out of character. It's more suited to a suburban area like Oshawa or Oakville, and it really will be jarring. So I just strongly really object, and thank you for your time.
Okay, thank you. We'll just wait to see if any of the members have any questions for you.
Okay.
Any more questions for the neighbor at the 358? She's over here. Oh.
I'm on this side, the east side, where there is a driveway now, but no more. I'm a corner lot, so part of my house faces King George and part of it's...
Your address is King George, but you front...
No, I'm 358 Prince Edward Drive. The front is on on Prince Edward. So I have like the back of my house with all my bathroom windows,
It's your back.
You're back facing their side.
my bathroom windows, my kitchen window, the side of the house. I have a sunroom, and we have like a shared hedge.
Okay, so let's, Mr. Milne Price is going to respond to your concerns and those of Carol Arundel.
Okay.
Okay.
Thank you both to the neighbors for their comments. Absolutely, I'll respond to them. The first point that I'd like to raise is that there are some neighborhoods and zones that regulate the total amount of GFA on a lot. This is not one of them. In this case, it is a ratio, and the intent of that provision is to permit a larger house on a larger lot. Absolutely, the point was raised that this is a large lot. In my opinion, it's suitable to have a larger house on this lot. I'll note as well that while it is a large house, it's not the largest house within the broader neighborhood. There are several others that are similar or greater size. In fact, I would point to 1 Kingsway, which has a total GFA of over 800 square meters, as well as 103 Kingsway, which has a GFA of just over 430 square meters. So in general terms of what we're providing for the total GFA, it is similar to the larger lots that do exist in this neighborhood, because there is quite a range in terms of the lot sizes that exist. Now, in terms of the third story comments, this dwelling does have a third floor that you can access. However, if you look at the elevations, I believe that to most, the dwelling does appear as a 2-story building with windows in the roof line, which is something that is common throughout the city. The comment was made in terms of the height, that the difference is only 3 inches per floor, and I'd point out that that demonstrates how minor the height variance we are seeking really is. In terms of the tree protection comments that were brought up, the city tree, as I mentioned, was indicated in the arborist report that it is in very poor condition. However, regardless of the decision that committee makes today, it is urban forestry that will have the final say, as they did give an alternative to their request for denial of variance 6. They did offer a condition of approval should the committee see fit to approve. So that is another option that is before us. The neighbor at 37 King George's mentioned that she would like to see at least one other house where the situation we are creating exists. And I would point to the house at 37 King George's, which has the exact same situation put onto it, putting the exact same situation onto 39 King George's, rather, where in pretty much the entire length of that house is along the rear yard. And there are other similar examples throughout the neighborhood, in part because of the winding road of King George's. In terms of the petition letter, I'll just quickly comment that while there is a wide range of area that the property owners went to, I can't say why or when those signatures were actually signed. I always put those petition letters out because it facilitates conversation between the property owners and between the neighbors, which is always important for these types of applications. I'll note as well that this application was deferred, so there was a significant amount of time and consideration spent to meet with any adjacent property owner that had an issue, and although objection letters were posted to the AIC, no specific concerns were mentioned to either myself or to the property owners. Now, to quickly speak to the concerns brought up by the neighbor at 358 Prince Edward, I'll note that the cabana has no more variances associated with it. The location of that cabana is in a position that is as of right. With regard to the east side yard setback, I'll note again, I noted in my presentation that the dwelling at 358 Prince Edward drive is actually located closer than what we are proposing. So we are not matching the setback, we're providing an increased one. I'll conclude my comments just by noting that while I did review this application, I do find that it meets the 4 tests. My opinion is not the only one that you should consider. You should, of course, consider the residents as well as the planning department, which concurs with my assessment.
Okay, thank you, Mr. Milne-Price, for your rebuttal. I'm just going to say what my comment is. I agree with you normally, you know, big lot, big house, small lot. That's when it's sort of more uniform. And obviously, even today, people came and say, oh, you know, my lot's shorter, so they should, you know, it's going to look at a let me build with the other people, my lot's shorter, but it really doesn't affect anything. In this case, I do have some sympathy for the neighbors that maybe not, you know, dollar for dollar, big lot, big house, because you're using that, it's in a regular, you're using the little hockey stick, that void in the back, to buttress the building at the front of the lot. And obviously, these are the 2 most affected neighbors. So the question is, do you get full points for your size of FSI, given that it's sort of not it's the opposite of people who come to committee, including this morning, and say, look, my lot is just a little not as deep, so my GFA is higher, but it's the same house that my neighbor has, but my lot's shorter, so let me have my house. So you're basically the flip side of that. And the question is, you have some sympathy, I guess, because of that it's odd lot shape that you're using the coverage in your back to push it all at the front. That's just a comment.
Actually, I have a comment as well. You used a couple of examples, but none of them were on King George's Road.
If you'd like, I can provide some examples on King George's Road in terms of
GFA that is similar or greater than?
Not of GFA that is similar, because this is the largest lot along King George's Road. It is absolutely a unique lot size and shape, but there are absolutely FSIs that are higher than what we're proposing.
Yeah, on the Kingsway, you used those 2 examples. Anyway.
Yeah.
Okay, I do have a concern with the east side setback. I mean, you're building a new house. I don't understand the hardship around complying with that. It's not much. And given that you're transferring the massing from, as the chair pointed out, a hockey stick situation to the front of the house, that adds to the massing as well. Also have a concern with the width of the driveway. It doesn't really need to be that wide. Are you saying that in your arborist report that tree, the city-owned tree in the boulevard, it needs to come down anyway?
Through you, Mr. Chair, yes, that is what the arborist report states. Obviously, I can't confirm that. I'm not an arborist, but it does state.
Does City Forestry agree with that?
City Forestry has not specifically commented on the health of the tree, but I would again note that up to a 6-meter driveway is permitted on this lot due to the lot frontage size.
If you do a wider garage.
That's correct.
But you're not doing a wider garage.
It's based.
So it's a semantic argument.
Well, it's actually based on the parking space size. If you look at the first floor plan, you'll note that the size of the driveway is generally the same width as the parking space. However, the zoning examiner has simply calculated the parking space to be 3.2 meters, which is much smaller than the width of the garage.
Okay. The forestry is asking for refusal or condition 2. Condition 2 refers to a private tree. So which private tree are they referring to?
I believe the tree that it is referring to is in the back of the yard, in the rear yard. So let me pull up the plans here. On there's a tree on the tip of the hockey stick shape, to put it like that.
Is that the one in the neighbor's yard?
I believe it's a boundary tree, and it is proposed to be protected.
Okay.
So how many so I see, like, the other thing is that I mentioned the massing based on
And
the
you're
size
looking
of
at
the lot.
5,242 square feet.
It's your permitted 362.8 square meters, and you're going to 487. So it's over like 125 square meters more, which is like 20. Like it's a big percentage.
It's a
and it's
34%.
based on the big lot, which my position is, if it's a big lot, the reverse of the small lot, saying it's compatible. It's going to look like a big house. It's going to look big. How many of the other houses around there are 5,000 square feet?
Yeah, that's the concern, is given the shape of the lot, the massing is going to look disproportional to the portion of the lot that you can see from the street.
You know, if you came in with the no variance on variance 1, so you were still at 362, it would still be a big house, but then you'd be in a stronger saying, hey, I'm entitled to do that. That's the size of my lot. But to me, it's pushing the envelope a little, because you're taking that extra square footage and you're still asking for about a 25% variance. So it really I'm just saying, the build form, if we approve that, we drive by that, and we go to visit this lady next door, are we gonna, is it gonna look like a spaceship on this, next to it? You don't have renderings here, right? You didn't do renderings? I love renderings.
No, there are no renderings prepared,
Yeah,
only elevations.
So I'm just saying, to me, the renderings would help here, because to me, just guessing from doing the math, it's going to be a big house.
Absolutely. I'll note that a good portion of the GFA is also from that third floor.
Okay. Yeah.
So that will be entirely within the roof line.
Right. Which I've never had a problem with people building inside an attic, or if it looks the same from the street. Who cares if they have extra living space? It's in a single family home situation, certainly. Okay, so anyone else have any comments? I would have liked to seen a rendering, or sometimes in the old days, people come with these they make a little model, which are really nice to see. That's just my comment. Mr. Davis?
Yeah, Mr. Chair, I just have another question. Could you repeat your justification for the dwelling length and dwelling depth, variances 3 and 4?
Absolutely. So because of the fact that the front lot line and required front yard setback is on an angle, the requirement for building depth, which is based on a measurement from that front yard setback, that requirement is also a line that is on an angle. So if you look at the site plan on the east side, the limits of the patio there, the underground portion, that is actually the limit of the rear wall in terms of the permitted building envelope. So an as-of-right building could be permitted. Really, the only difference is that an as-of-right building envelope would be on an angle. We would have a house as a parallelogram. And so what this application really is trying to do is to permit a house that is not a parallelogram that uses right angles.
I personally don't have a problem with the length or depth, and here's a suggestion. What if I don't make motions, but what if the committee were to approve everything but variance 1? So you can build your GFA based on your big lot, but not with the 25%. Would that application something your client could live with, or they have to come back or appeal this one or whatever? I'm just wondering. That's my only objection, is that you've got a big lot with excess in the back. It's sort of like a builder when they used to buy the air rights in the building next door.
Mm-hmm.
Okay. Same thing. So the question is, could your client build they get all these variances except for variance 1? They can build a 380 whatever square meter house.
I can say that would absolutely be preferable to refusal of all the variances.
Anyway, okay. Members, any other questions or a motion, and then we can go home. Just in time for rush hour.
Yeah, I'm still not comfortable with variance 2 as well, so.
Yeah.
Yeah, I mean, if I'm going to do a recommendation to approve, I would deny the first 2 variances.
Well, the east side, is that the lady?
Yep.
That's 350. Yeah.
Yeah, because that backs on. Like it's the side yard to this, but it's a
Makes
rear
sense.
yard to the other.
It's inches anyway, but
It
why
is,
exacerbate,
but it's a new build, right?
exacerbate on
Yeah.
the impact on 358. So, anyway, so perhaps a motion without variances 1 and 2, rather than a refusal. Well, Mr. Milne Price said he would be, that would be preferable, and perhaps he'd have to then come back with, wouldn't have plans to go along with
We
that.
wouldn't be approving plans because.
Right, we can't.
Yeah, and you wouldn't put the planning condition in because,
Right, exactly. He'd have to go back and live within the variances. Madam Secretary Treasurer, do you have any comment about
actually,
that?
I have a problem with that. Because then we're giving carte blanche on the depth, on the length, and I don't think you want to do that.
Yeah, you can't tie it to a plan that's not part of the plan.
Yeah, because you've got a length of 23 meters.
I'm happy this is the last application, but it's a
Yeah.
very good point. Very good point.
So,
I guess you'd have to refuse.
to me, that's.
Okay, I tried.
That's a motion to refuse.
Okay.
If I may, I'm not sure.
We're in committee now, so I tried to try to some way, but you're
Yeah.
right. It
No.
won't work.
You know,
because-
if we were approving 17 and 21.1, no problem.
Yeah, okay.
But I can't go for
Okay,
23.
so do we have a motion? Was your motion to refuse then, or?
Yeah.
Okay, seconded for that? Mr. Taylor, all in favor? Unfortunately, the application is refused. Suggest you perhaps have your client come back with something closer to the GFA as of right, and perhaps look at the impact on the 2 adjacent neighbors.
We'll rework it on
Understood.
appeal.
Yep.
Thank you very much.
Thank
Have
you.
a good afternoon.
And thank you, neighbors.
Thank you. Okay, 25? Oh, no, that's just goes to, that's Barb. Right, Barb, so do we need a motion to adjourn?
I'm happy to make that motion. Of course.
Seconded by Mr. Palmer. And we stand adjourned, and we'll see you next time. The date of our next hearing?
Oh, we're getting feedback.